I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are at number 170 on our compilation list. Today, we will be in 3 different courtrooms. Before I give you the rundown on those courtrooms, don't forget chapters will be added to this compilation. Also, commentary will be left in from some of these previous proceedings that are going to be a part of this compilation. Also, don't forget to like, share, comment, and subscribe. It seems like YouTube is starting to get us back on our regular algorithm flow. A lot of you guys, well, I won't say a lot of you, but some have mentioned not seeing notifications and stuff like that. But YouTube is kind of funny that way. You know how they do their sharing and the algorithm, and it's just all weird. So, you know, thankfully everything is starting to flow back together again. So I'm grateful for that, and I appreciate you guys for doing your part and helping us get back on track. And with that being said, let me give you the rundown of the courtrooms that we will be in on today. The first courtroom we will be in, let me shout out Sovereign Citizen Chronicles for sharing this recent video with me, recent proceeding in Judge Kristen Simmons courtroom out of the state of Michigan. Second, we will be in the courtroom of Oakland County, Michigan. And last but not least, we will be in the courtroom of Judge Simpson for a very familiar sovereign citizen right up there with Eric Martin. And when I say that, some of you guys already probably know who I'm talking about. But I'm going to share a proceeding that I covered on him some months ago that, once again, the algorithm didn't really give much love to, and it definitely was an important proceeding and felt like they should have pushed it out to a lot more people, but they didn't. But I'm glad that I'm able to add it here in compilation number 170. So that will be the third courtroom we will be in. So today we are staying in the state of Michigan. And as always, guys, I appreciate you guys here on Sovereign Citizens Hall of Fame. And now it's about that time. Let's jump into 170.
Okay, on the record, in the matter of Corey Deshaun Blocker versus South Washington Park. This is 25-06485. Is that you, sir?
That's me. Yes, ma'am.
Come forward. Council appearance.
Good afternoon, Your Honor. Jeff Klug appearing on behalf of defendant South Washington Park.
Okay, and your name for the record, sir.
Corey Deshaun Blocker.
Okay, Mr. Blocker, as present as the plaintiff and pro per, and then Mr. Klug, you are representing South Washington Park. This was scheduled for motion for summary disposition, which the defendant filed against you, Mr. Blocker, but I don't see where you responded.
Yes, I responded by affidavit of fact.
Affidavit of fact.
Yep.
Read the title is an answer. Let's see if this is.
That the defendant has not disputed line for line.
Okay, that is not a response to a motion in brief for summary disposition. I'm looking at an administrative complaint objecting to summary disposition. Is that what you're talking about?
That is a response.
Okay, that's, well, you said you responded by
And I got
affidavit.
affidavit of fact in there too, to responded to everything that they done to me, that he has not defended, not one line. I have affidavit of fact and an administrative complaint to respond to his complaint. So I have responded, and he has not responded back.
Mr. Blocker makes Corey Deshaun Blocker makes said complaint for this court record and on this court's record. Corey Deshaun Blocker makes this administrative complaint to object the summary disposition motion for January 12, 2026 for the delay tactic it is by this court. First, Kristen D. Simmons, should be Judge Kristen D. Simmons, recuse yourself as you are supposed to do by law. Second, until the defendant can respond by affidavit only, there is no need for summary disposition because this case is going to be granted by judgment by default in the tome allowed by law to be responded. The fact that the defendant cannot respond and Kristen D. Simmons was supposed to recuse herself furthermore proves the fraud upon the court that was committed and the fraud upon the court still being committed because the judge is providing an unfair advantage to try and save her from being hung to death for fraud upon the court committed by Kristen D. Simmons. Therefore, the defendant has the time given by law to respond to this case will be granted full and final judgment with no further need for litigation. That's the response you filed?
No, I've got an affidavit of fact. Can you read my affidavit of fact?
We're gonna stop here because as I perceive this is the response you received, Mr. Clue?
Yes, Judge, that is the response that we received.
There appears to be some threats in this response. What does this mean? Because the judge is trying to save herself from being hung to death.
That's brought upon the court to you as treason against the interstate commerce and the United States Constitution. And dropped the fraud upon the court. All I stated was
I'm asking a specific question.
All I'm doing is giving a specific
You're going to answer my question, and you're going to operate with decorum and control over yourself.
I got it.
Or you see this officer back here? You see him? I will put you in custody for contempt.
On what ground?
Yell in my court and
I didn't yell at your court.
Control yourself. I'm going to ask you another question. You're going to answer my question. What does it mean when you say the judge is trying to save herself from being hung to death? Is that a threat?
No, ma'am. Like I just explained, that is, if you are convicted of fraud, because I'm going to go down and file a judicial misconduct against both y'all, because he didn't send the mail so I could sit up here and defend against that, which is in my affidavit of fact. That's what I'm saying. My affidavit of fact that he hasn't.
Calm down.
Okay, my affidavit of fact that he didn't defend, it states that he knew my exact address and sent it to the wrong place. So I didn't even get to the defendant until after I sent the affidavit of fact.
He knew your exact address.
He knew it exact because I sent it.
What to the wrong address?
I sent to change the address and he got it.
What did he send? What did he send to the wrong address?
He sent the whole complaint, the motion for summary judgment. Summary deposition. He sent all that to the wrong address purposely. And you can see when I sent the change of address, it's after he sends the summary deposition to the wrong address. That's judicial misconduct.
So he's not a judge, sir. So he doesn't get judicial misconduct. Okay. Did you receive?
No, I didn't. I had to come up here.
Did I ask the question yet? Did I ask a question?
All right, man.
Thank you.
I got with this one.
Do you have control over yourself?
I sure do.
Okay, well, that means you need to wait till I finish asking the question before you can answer it. And you also need to control your tone. Do you understand that? Because if I perceive your behavior to be a threat, you're going to go into custody. Do you understand that? Did you receive his motion for summary disposition?
No, ma'am.
Okay, when did you find out about it?
When I came in here to file for motion for judgment by the court.
Okay, and that's when you were notified that he had filed a motion. Okay, this looks like this was back in November. Counsel, where did you serve the motion for summary?
Your Honor, in Mr. Blocker's administrative complaint, his address listed is the 1704 Kelly Road, Mason, Michigan, 48854. That is where we serve the motion for summary disposition on. And his administrative complaint objecting to the summary disposition, he dates it December 3rd, 2025. So he filed a response that he dates December 3rd, 2025. So that's, I mean, I'm looking at this. Our motion for summary disposition was dated November 13th, 2025. And proof of service should have been, my assumption is that same day. Let me look at the proof of service here attached. Yeah, November 13th, 2025. We sent the motion for summary disposition to his address at Kelly Road, 1704 Kelly Road, Mason, Michigan. He then filed that administrative complaint objecting to the summary disposition. He dated it December 3rd, 2025. This court then renoticed the hearing from the January, what date was that? The January date to today's date at 2 p.m. and they served a notice to Mr. Blocker at the P.O. Box 11004, 315 West Allegan Street, Lansing, Michigan. So we served him with it, the address and information we had. He filed an answer to it. I don't know how he can say that he did not receive the motion if he filed an answer, a response to it. So
Oh, okay, so it looks like even if it was served on an address that had been changed, it looks like that was within short time frame of you sending this change of address, which I'm looking at the change of address and when it was dated for the court. Nonetheless, it looks like that issue has been cured and you've responded to the motion, at least to what you believe is a response. I don't see where you address the statements that they made in the motion.
On my fact, can I speak? Because
yes.
my affidavit of fact addresses every one of them, and that's after his response. My affidavit of fact goes through everything he stated. My affidavit of fact breaks it down line by line.
You're talking about the administrative complaint to change your address?
No, I'm talking about the administrative complaint that's an affidavit of fact. I need to adjourn to get my paperwork so I can come back and do this. But I can
promise you one thing. This is going to get resolved today. There will not be an adjourning and coming back.
But I have filed a response and I filed an affidavit of fact. That affidavit of fact in there is evidence. It's proven by law. As long as I got that affidavit of fact, I defeated his motion for a summary deposition because I have the affidavit of fact in it, and that's evidence.
This is the administrative response and affidavit of fact filed December 29th, correct?
And that's evidence.
Corey Deshaun Blocker makes this administrative response and affidavit of fact for this court's record and on this court's record. Corey Deshaun Blocker makes this administrative response by affidavit of fact to respond to the defendant's motion for summary disposition under grounds Michigan Court Rule 2.116 and under MRC 2.116C10, which this affidavit of fact defeats the defendant's motion and gives the plaintiff grounds that relief must be granted. Corey Deshaun Blocker states for the record with this affidavit that on November 15th, 2023 at around 2 a.m., Corey Deshaun Blocker, resident, was broken into by Lansing Police Department for what should have been a civil complaint. That never happened because the defendant allowed the situation to escalate, even though Corey Deshaun Blocker on many occasions went to the defendant explaining the problem that neighbor Andrew Workman was causing, banging on the walls for months. The reason the defendant allowed Andrew Workman to bang on the wall was because the defendant was retaliating against Corey Deshaun Blocker for filing a lawsuit against the defendant because of repeated requests for the first month's rent and deposit, which Corey Deshaun Blocker said the computer proved. But the defendants for 3 months sent letters demanding the payment. After the lawsuit was filed, the defendant finally acknowledged payment, but then the banging on the wall by Andrew Workman began. And even though the defendant and the Lansing Police Department stated Andrew Workman was going to be evicted, Corey Deshaun Blocker is the one who was illegally incarcerated and evicted on January 15, 2024 by the defendant. Because this court never allowed Corey Blocker's appeal to proceed, that the record show he verbally requested in court. Then there is the fact that Ingham County Jail purposely held Corey Deshaun Blocker's written motion for appeal and never allowed it to reach the courts in time. Then there is the fact that Corey Deshaun Blocker's puppies were stolen out of his residence by Ingham County Animal Control with the consent of the defendant and no written consent from Corey Deshaun Blocker to enter his residence, which is illegal and makes the defendant liable for Corey Deshaun Blocker's puppies being killed and sold by the Ingham County Animal Control. Then there is the fact that Judge Carol Koenig and Cole then illegally incarcerated Corey Deshaun Blocker for child support case that was closed in 2005 when the child died. But both judges reopened the case without congressional authority to do so by law, which violates Corey Deshaun Blocker's Sixth Amendment because the codes that were used violates the U.S. Constitution 14th Amendment right to due process. Furthermore, giving grounds that relief can be granted. Then there is the fact that Corey Deshaun Blocker was illegally incarcerated for 4 months, which the fact that Corey Deshaun Blocker was not convicted on any charge proves that the defendant and its affiliates concocted and purposely committed treason against the United States Constitution for the purpose of denying Corey Deshaun Blocker from being made whole. Now there is the fact that this court is still committing fraud upon the court by the judge not recusing herself for conflict of interest, which was done in the case 23-028252LT, because she by law must recuse herself by law. Then there is the fact that the docket text proves that the defendant's motion was sent to the wrong address on purpose. The courts knew it was sent to the wrong address and committed fraud upon the court by allowing the motion date to be set without proper service, which furthermore proves the defendant and their affiliates' guilt beyond a shadow of a doubt and grounds that relief must be granted by law. This affidavit was given in response for the purpose of giving evidence to defeat MCR 2.116C78 and MCR 2.116C10, which this affidavit of fact defeats both codes. Therefore, by law, the defendant has 10 days by law to respond by affidavit, only defeating line by line. Sign and notarize. Counsel, you can respond.
Your Honor, the defendant has failed to state a relief for which a complaint for which relief can be granted against the defendant. This all stems from the landlord-tenant eviction case that was filed in 2023. A hearing was held. My client was granted judgment in its favor. Mr. Blocker was not happy with it. He didn't follow the proper procedures to appeal that. Instead, he filed a complaint almost 2 years later against my client and alleging the same facts arising out of what the hearing already had pertaining to his eviction. The administrative complaint is attached as Exhibit 1 to my motion and to defendant's motion. And again, he doesn't allege he doesn't plead anything in which any kind of complaint can be asserted against the defendant. Instead, most of the complaint is alleged against you, Your Honor, and I find it very disturbing. I've never experienced this in my entire almost 18 years of practicing law. I don't know if you have, but in there, he demands that the judge who ruled in this case be hung to death for treason against the U.S. Constitution 6th and 14th Amendment. I have never seen somebody make these statements about a judge. And then he also goes on and alleges you should recuse yourself from hearing this case because you heard the original landlord-tenant matter. But the fact of the matter is, Your Honor, Exhibit 1 to defendant's motion for summary disposition is the plaintiff's complaint. He has not stated any kind of relief from which he can be granted against the what defendant did. In fact, most of it is directed against the court. So at this time, I would state that that defendant's motion be granted and plaintiff's case be dismissed with prejudice. Thank you.
Thank you. Did you have anything else you wanted
Yes, I
to
want
add?
to respond because what the law states is not me doing any derogatory to the judge. The law states for treason amongst interstate commerce and treason amongst the United States Constitution, what must be done. That he's sitting up stating that what the Constitution states, that is not here nor there. The fact that I gave evidence, because I gave evidence, new evidence of what sat back, because they didn't bring no evidence of the puppies. You didn't make them bring no evidence of puppies being walked around, none of the stuff that you granted. And that the fact that you recused yourself in that first case, like I said, I got to go get the paperwork. You did recuse yourself and then came into this case and didn't recuse yourself. Like I said, no matter what, I'm going to appeal because you did recuse yourself. Sent me the letter recusing yourself. Now that you're sitting here, I don't know what he's talking about. He got the letter that you recuse yourself too. You did recuse yourself. I'm not being derogative or nothing. That's a fact. You did recuse yourself in the first case. So how can you take this case on now?
Okay,
I'm done.
thank you. I'm glad that you're done, sir. Let me be clear. I distinctly remember the eviction. Mr. Blocker was in the custody of the Ingham County Jail. The court did not recuse themselves. They had no reason to recuse themselves. The court held a hearing on the eviction and the plaintiff was granted the eviction. What happened with your dogs and anything else after the fact, the court had no control over, nor did the court have any involvement. I do, however, in this case, have at least two instances where you have made filings where you mentioned that the judge, being Kristen Simmons, should be hung to death, which I take as threat. So that will be reported to the proper authorities for that purpose. As it relates to your complaint, I agree with the defendant in this case that you have not stated a claim of action upon which this court can grant you relief. Again, your complaint talks about an eviction that you had the right to appeal and did not properly file and proceed with an appeal. And then it also makes statements mostly against the judge who presided over that eviction and claims that you believe that that judge should be hung to death for the decision made in that eviction. So your request to have this case proceed cannot be granted. I have to grant the motion for summary disposition of the defense. Your case is dismissed.
Okay.
Any additional matters for the record?
No, Judge, I'll prepare an order.
Thank you.
Thank you, Judge.
Really quickly, guys, before we jump into the rest of our compilation, I just wanted to say quickly on this previous proceeding, being that it is a new proceeding, and shout out once again to Sovereign Citizen Chronicles for sharing this with me. As we can see, Mr. Deshaun definitely almost got himself in a lot of trouble playing around with Judge Simmons. If you don't know anything about Judge Simmons, she doesn't play that whole her being hung for treason. She was not feeling that. And we heard her say, listen, this is also going to be reported to the proper authorities because I take that as a threat and I take it personally. But we hear his arguments, the affidavit that he claimed he filed, the motions that he filed, none of it seemed to be any good and none of it helped the situation. And like the attorney for the plaintiff said, it sounds like he's more getting at the courtroom than it is that he's trying to figure out the situation that we have going on here with the rent and the property and so on and so forth. And with that, all playing out the way that it did, we see what happens. Obviously, he loses. The judge grants the summary deposition for the plaintiff. And, it was just over and done with. But it's going to be interesting if this gets covered again to see what happens with the threat that he made to her. Some of these sovereign citizens, they definitely be treading a very thin line. And, some of them have found themselves in a whole lot of trouble for saying some really crazy things on the record. But I talked enough. Let's go ahead and finish up this compilation, guys. As always, thank you for joining me. Back to 170.
And who is the individual? And sir, what is your name at the jail?
I'm Roman Campbell. I can place my status on the record if you like.
Yeah, hold on one sec. Yeah, I'll get to you. 1 second. I need to look over some things. Are you
Yes, sir.
representing yourself?
No, sir, I'm not representing myself. I'm presenting
Okay.
myself.
Okay. I mean, do you have is a court appointed attorney going to be speaking with you, or are you going to have a retained attorney?
No, sir.
Calling case Tom King 25 William Boy 00474 in the matter of Roman Curtis Campbell. Mr. Campbell, would you please state your name for the record?
Yeah, I like to state
Just tell
my
me your
name.
name. Yeah, go ahead. Yeah, all I have to do is say it.
I'm Roman Curtis Campbell, a natural person for life.
Okay, let me ask you this question, Mr. Campbell. Let's try not to talk together. I mean, I'm going to allow you plenty of time to talk because I have to. But are you representing yourself here today? You don't need an attorney, or you want an attorney?
No, sir, I'm not representing myself. I'm presenting myself. I don't need another man to present.
So are you presenting yourself? So you don't want an attorney, you're presenting yourself here today. Is that correct?
Yes, sir.
Okay. All right. Thank you, sir, for that.
You're welcome.
You're charged with domestic violence, as I've indicated. MCL 750.81, it carries a maximum penalty of 93 days in jail, possible fines of $500 and or both, not including any court costs. I am going to enter a plea on your behalf of not guilty on this offense. You will be given an additional, and you're also charged with refusal for collecting fingerprints and data, which the court is ordering that you do that. As I've indicated, I'm enter a plea of not guilty on your behalf for this matter. I'll indicate that you're self-representing at this time as well. I do have some other conditions for you before I set bond. You're not to have any direct or indirect contact with Marissa, Maurissa Smith. You're not to return to the premises known as Celeste Road.
That's my home.
Yeah. I'm gonna keep going, and then I'm gonna take all your questions at the end. So no problem. It's not, just hold on to that question. That's all. You're gonna have plenty of time to talk at the end. So do not return to the premises known as Road, West Bloomfield. You will not assault, beat, verbally harass, intimidate, or threaten any potential witness. This person may appear for all court proceedings. Do not leave the state of Michigan without permission of the court, and immediately notify the court in writing of any change of address or phone number. You need to provide the court with a valid address within 24 hours of your release. Do not leave the state of Michigan without permission of the court. You will not possess any firearms or other dangerous weapons. You shall refrain from using alcohol, any form of THC, illegal drugs, or using any medication. You must contact pretrial services within 24 hours of your release. That's at the 48th District Court in Bloomfield Hills. Pick up no new criminal offenses. And I understand you're self-representing yourself here today. The court will set a bond in the amount of $1,500 cash surety, no 10%. Sir, do you understand your bond, what I read off to you, your bond conditions?
Yeah, I understand all of that, but all of that.
Okay, now I'm gonna take your questions right now. Thank you very much. So what questions do you have for the court?
Can I place my status on the record, sir?
Absolutely, sir.
Okay, I'm Roman Curtis Campbell. I'm a natural person in full life, in propria persona, sui juris ser habitus. My nationality and citizenship being Moorish American national, unconditional heir, apparent vessel for the Moroccan Empire. I come at Northwest Mexico, at North America, North Gate, Turtle Island. I come under protection by way of Treaty of Peace and Friendship, 1836, between the United States Service Corporation and the Moroccan Empire. I also would like everybody else that's involved with this matter to place their status on the record, and so that it can be noted. And also, I'm not representing myself. I'm presenting myself. Not only that, I'm not standing a surety to Roman Curtis Campbell in all capital letters, ins legis, corporate entity. So that be noted for the record, please, sir. I also I also reside in domicile at, that's my address, that's my home. The defendant, witness, or whoever that is, Marissa, she doesn't live there. And so that's where I was kidnapped from. That's my home, sir.
Okay, and I will allow you to go back there one time and one time only with a police escort to obtain some minor personal property. That's with a police escort only. Otherwise, you cannot go back to that location. You have another court date coming up. Your next court date is going to be your pretrial date. That date will be provided to you prior to you bonding out. If not, you're going to have to contact the 48th District Court in Bloomfield Hills. Other than that, best of luck to you, sir. Officer, we're all set here. Thank you very much for your time.
If I could, Your Honor, we would like the refusal of the booking process that he not be released until that is completed.
Absolutely. He must submit, as it relates to the booking, he must submit to the booking processing in this information, including fingerprints, which is the biometric data. He must provide that information prior to release as well. You're all set, officer. Thank you.
So I'd like, one more thing, sir, I'd like to invoke my treaty right to consular jurisdiction. I've been asking someone to be that's competent in the notification and access manual, and I haven't been given that right. My rights have been violated as far as all of that's concerned also. So.
Okay, make sure you mention that to the judge when you see the judge. So thank you very much, sir, for that. And officer, we're all set.
Thank you, Your Honor.
Okay, must submit the biometric fingerprint data prior to release.
Does call the case. This is of the people versus Daniel Magoo.
Alex Feltus for the people.
Good afternoon, Your Honor. Alex Lauren Green on behalf of Mr. Magoo. Thank you. Mr. Magoo, can you state?
Daniel Magoo.
Thank you.
Your Honor, the defense is ready to proceed to examination in each matter. I'd ask for a sequestration order.
I anticipate one witness in each case.
All right.
So it should be over.
All right. Witnesses are ordered sequestered for what that matter.
Actually, Your Honor, I have
you may have. Yes.
I have an issue. I have been requesting the last time I was here, requested that the prosecution provide explanation for the undue delay.
Your Honor, my advice to Mr. Magoo was that I'd be handling the examination today. So just for purposes of the record, I'm advising you not to make any statements on the record of this.
Well, I do actually also want to provide notice that this case is being removed under 28 USC 1455 to the Eastern District of Michigan under case number 25-12440. And due to due process violations that I've been facing.
I don't know what you're talking about. The case has been removed.
I'm sorry. I'm providing notice of removal under case number 25-12-12440.
Have you talked that over with your attorney?
I let him know.
Your Honor, and my advice was I'm not going to be joining in any collateral motions or actions, and that I would address the case.
Are you aware of any motion that seeks to take this case to federal court? I'm not sure how that would even happen.
Right, Your Honor. And Mr. Magoo told me that he has been seeking that action, but I informed him that I am not a member of the federal bar and I would not be joining him in any of those actions.
Just providing notice.
Okay, I don't know what the notice does, but I'm not. If I don't have something in writing indicating some procedural aspect to it or anything along those lines, the court's not.
Can I give this to you now?
I would advise against.
I don't even know what is.
Notice of removal pursuant to 28 USC 1455 criminal.
What does that statute read?
The criminal proceedings removed to federal court under federal questions involved in this case.
I'm not gonna get a bite as to what federal questions, because I don't think there are any federal questions.
Fourth Amendment violation.
which adequately a state court could handle if that were an issue. So I don't think there's any need for the court to even deal with that. I don't know that anything's been filed with the federal court regarding that or anything
It's
else.
filed under case number 25-12440. Eastern District of Michigan.
Are we ready to proceed?
Defense is ready to proceed, Your Honor.
People ready to proceed?
Yes, Your Honor.
All right. Which
If
case would you?
we were talking over each other, I apologize. If it pleases the court, could we start with the OWI matter?
That being 0523.
I believe that's correct.
That's fine. Start with that one.
Thank you. A couple of housekeeping matters. The court is in receipt of the amended complaint, which is just typing it correctly as a felony form. Is that correct?
I do have an amended information. I do.
Excellent. And Your Honor, I do believe defense is stipulating that the defendant has 3 prior OWI convictions.
So stipulated, Your Honor.
So there's a step to the priors.
There it is, Your Honor.
All right. Anything else?
I do think defense is going to stipulate to people's exhibits 1 through 10, which are photos, but maybe not.
Your Honor, I did have an opportunity to review those and we would so stipulate.
And then people's exhibit 11 is a laboratory report. I'm not sure if there'll be a stipulation to that as well.
We would so stipulate.
I'm sorry.
So stipulated, Your Honor.
Okay, so exhibits 1 through 11 are stipulated to.
Thank you, Your Honor.
Therefore admitted.
Thank you. I do expect that the officer in charge of the other matter will probably be informed at some point if sequestration order is otherwise enacted and followed. So I will call Paul Corey to the stand.
All right. Please come forward to be sworn.
Take a seat, raise your right hand. You solemnly swear to affirm the testimony about to give the truth, whole truth, and nothing but the truth, so help you God. State spell your first and last name for the record, please.
Paul Corey, PAULCORRIE.
All right. You may inquire.
Good afternoon, sir. How are you employed?
I'm employed with the Milan Police Department.
How long have you been employed with the Milan Police Department?
A little under 2 years full time.
Do you have prior law enforcement experience?
Yes, I worked at the Washington Sheriff's Office prior to that for about 15 years.
Were you working for the Milan City Police Department on or about March the 27th, 2024?
I was
Do you recall what shift you were working that day?
up in my shift 6 p.m. to 6 a.m.
And were you ever at the location of Dexter Street and Arcona Road?
I was
About what time were you at that location?
about 1:35 or when I was dispatched there.
Why were you dispatched there?
The 911 caller had said that there was a single car crash into a gas station in that area.
Did the 911 caller, did you have any other information in your dispatch when you were headed that way? Yeah, it's not being offered to prove the truth of the matter asserted. It's being offered to prove why he was headed to that location and other additional information that may have hastened his speed going that way.
All right. I will overrule the objection regarding hearsay. I'll accept it for what it's offered for other than the truth of the matter.
Thank you. Did you have any other information from the dispatch?
I believe that the caller said that there was a single subject walking around outside of the car and possibly injured.
And did you make that location?
I did.
Do you recall about how long it took you to get there?
Maybe about 5 minutes less than.
Less than 5 minutes? When you arrived, what did you observe?
A car that I saw a SUV that appeared to have been crashed into a sign outside the gas station here. Dexter, and there was a single male subject standing around the passenger side of the vehicle.
What did you notice about the vehicle first?
It was definitely crashed there and not parked. There was some extensive front end damage.
And Your Honor, may I approach with People's Exhibits 1 through 10 for the court?
You may.
Thank you. Officer Corey, you took some photographs that evening.
Yes,
Did you take a photograph of the vehicle as you found it?
I did.
Actually, more than one, would that be fair to say? And when you saw the vehicle, how did you determine that it had been crashed as opposed to just parked there?
Due to the amount of front end damage that it had, and it was still in contact with the signage there.
Did you make any observations about any other parts of the vehicle?
It was the windshield was smashed in a particular fashion.
And
It
go ahead.
appeared that it was impacted from the inside rather than the outside.
How could you tell that it was impacted from the inside rather than the outside?
It was falling outward instead of inward, and there was no like gouging from the outside of the windshield.
And when you were looking at the windshield, would you describe the cracking in any particular way?
In a circular fashion. It's brought off the driver's seat.
Did you look inside of the vehicle?
Yes.
Where did you observe about the inside of the vehicle?
There was quite a bit of personal property inside of the vehicle, and the passenger and all of the front and rear passenger seats, indicating that there was probably only one occupant at the time of the crash.
Did you look at the windshield?
Yes.
What did you observe about the windshield?
What stood out about the windshield was there was a lump of human hair attached to the cracks in the impact area on the inside of the windshield.
How would you characterize the color of the hair that you saw?
Light brown, maybe dark blonde.
Did you make contact with any people at that location?
Yes, there was a male subject standing near the passenger side of the vehicle when I arrived.
Do you see that person in the courtroom today? Can you tell me where that person is sitting and what they are wearing?
Seated at the defense table wearing the green jumpsuit.
Your Honor, may the record reflect that witnesses identify the defendant?
No objection, Your Honor.
Record shall so reflect.
And sir, when you made contact with the defendant, what did you talk with him about, or what did he do?
I asked him what had happened.
What did he say?
He said I wasn't here.
What else did you notice about his appearance?
He was bleeding from a cut or some type of injury. There was a lot of blood. It was kind of hard to tell where it all was coming from. It appeared it was bleeding from the top of the head.
Did you notice anything about his clothing?
It was disheveled. There was blood on it. Front zipper was down. The zipper was down on his pants.
Did you look at the color of his hair?
Yes.
Based on your observations, did that appear consistent with the color of the hair in the glass inside the car? What happened next?
He maintained that he was not driving the vehicle. He could smell the odor of intoxicants coming from him. We called for medical assistance just based on his injuries. And so while they were on the way, asked if he would take a preliminary breath test, which he agreed to.
Without getting into the results of the preliminary breath test, did you make a determination about what had happened that evening?
It appeared on his face that he was driving the vehicle and it got into a crash. And he may have been intoxicated while he was doing it.
Did you place him under arrest for OWI?
Not at that time.
When did you place him under arrest for OWI?
After the ambulance came, it was determined he was going to go to the hospital while he was receiving medical treatment, and I read him his chemical test rights. I advised him he was at that point that he was under arrest.
Did he agree to take a test?
No.
What happened?
He refused to take a test. Poor judgment on my part. I did not have him restrained in the hospital bed while I left I believe that his injuries were significant enough that he was not going anywhere. I went out to my car to start preparing a search warrant for his blood, at which point a nurse came out and told me that he had fled the hospital.
Did you find him?
With some assistance from Washington County Sheriff's Office, yes, I did.
Where did you find him?
An apartment complex just south of the hospital.
Were you able to take him back to the hospital?
Yes.
And did you complete your search warrant?
Yes.
Was it executed?
I just a note for the court, Sergeant Crusadis, for it helped me prepare the search warrant while I was dealing with Mr. McGu's hospital. However, I did review, since I was going to the warrant, I did review to make sure it was accurate based on my observations at the time of the incident.
Did he make I'm sorry, go ahead. No, I'm so sorry to interrupt you, sir. While you were waiting to do the blood draw, did he make any statements to you?
He looked at my uniform and appeared to be confused as to why he questioned me as to why Milan, the city of Milan, was doing all of this. And
what did you say to him?
Asked him where he thought he was, and I said he was in sleep. Thought he was in sleep.
Did you ask him to perform standardized field sobriety tests?
I did not.
Why not?
Mainly due to his injuries, and even though he did comply with the request for a PVT, he was generally uncooperative with most things that we were trying to get him to do, or asking questions about what had happened. So then based on the extent of his injuries, we were more concerned about getting the medical attention at that point.
In your training and experience with administering standardized field sobriety tests with people who've been in traffic crashes that have injuries, is there any guidance that you've received from NHTSA on that?
It can be, especially with what was clearly a head injury that was sustained in a vehicle crash, it could have impacted the results of the standardized field sobriety test.
Your Honor, may I approach with People's Exhibit 11, the laboratory report?
You may.
And Officer Corey, you did receive a laboratory report back in this case? And do you recall what the VAC was?
I believe it was 0.127.
What did you do with the vehicle? Or what was done with the vehicle? Let me ask that. Do you know what happened with the license plate?
We confiscated the plate as the operator at the time, who we believed to be Mr. Magoo, had several prior convictions for suspension and operating while intoxicated, requiring a plate confiscation.
Pursuant to state law, you had to take it. And I may have a moment.
May. I do have one question. How much time elapsed between the time you were notified that he had left the hospital and when he was located? Do you know?
I believe it was about 40 minutes, Your Honor.
40 minutes?
40, yes, Your Honor.
Okay. All right.
Officer Corey, Milan, what county is that located?
Well, that's interesting.
Correct.
Half in Monroe County and half in Washtenaw County. The incident itself occurred in Washtenaw County.
Thank you. And that is in the state of Michigan?
Correct.
Milan kind of abuts the two counties, correct?
Yes.
Thank you. And Your Honor, I pass the witness.
All right, cross-examination.
Thank you, Your Honor. May I inquire? Afternoon, officer. My name is Alex Warren Green. I represent Mr. Magoo in this case. So you're dispatched for a single vehicle accident, right?
Correct.
And that's at a mobile gas station, and it appears there was an accident from an SUV into the sign, the mobile sign, right?
Correct.
And like you testified on direct examination, there was a 911 call placed, and that person didn't provide a name, did they?
They may have. It's something that I didn't end up following up on.
So you never talked to the caller, did you? And are you aware if anyone talked to that caller?
I am not aware that anyone did.
So as soon as you get there, Mr. Magoo is on the passenger side of the vehicle, right?
Standing outside, it's on the passenger side.
Okay. And that car was not registered to Mr. Magoo, was it?
Correct. It was not.
And like you testified on direct examination, he had a wound to his head, right?
Yes.
It's bleeding pretty bad.
Yes.
There was an injury to the front and back of his head, right?
There's photographs of an injury to the back of his head, yes,
Okay.
and the front.
And he appeared to be dazed.
Yes, it was difficult to say if he was out of it due to the head injury or his level of intoxication, maybe a bit of both.
And you didn't conduct the field sobriety test because you were concerned that the head injury you observed might impact the field sobriety test, right?
There's a possibility, yes.
So you testified on direct examination, you saw the windshield was smashed and you saw blood, right?
Correct.
There's a chunk of hair in the windshield, right?
Yes.
You take a picture of that?
Yes. Let me backtrack. Sergeant Mercedes actually took a photograph of it.
Okay. And most of the time you're talking to Mr. Magoo, he was wearing a hat. You recall that, right?
I don't recall that. You may have been.
So it's dark outside, right? And
You said a yes, 'cause I don't think we got.
oh,
Oh,
so
I'm sorry, Your Honor.
It's okay.
Yes, it was.
Okay, go ahead.
and there's a significant amount of blood on his face and it's going into his hair, right?
Correct.
Okay. In this case, you did submit evidence to the crime lab for forensic analysis, right?
Blood test, yes, blood sample.
Right. So no hair follicles, right?
No.
And there was no attempt to obtain any forensic match between the hair or the blood that was found in the car with any hair or blood from Mr. Magoo's body, was there?
You were correct, there was not.
Okay. On direct examination, you talked about field sobriety tests. You said you're trained in the administration of field sobriety tests, right?
Yes.
And you forewent the field sobriety tests in this case, but no one asked him at all to perform those field sobriety tests, did they?
That's correct.
And after this initial interaction, when the ambulance arrives, he goes to Trinity Ann Arbor Hospital, right?
Correct.
And did you accompany him in the ambulance or you follow behind?
All behind.
Okay. And you read him his chemical rights at the hospital while he's in the bed, correct?
Correct.
And he refused at 2:51 a.m. Is
That's
that?
correct.
And after he refuses, you leave the room to go and work on the affidavit for the search warrant, right?
Correct.
And then Mr. Magoo vanishes.
That is also.
Okay. You didn't see him leave.
I did not.
You had no idea where he was.
Nope.
And like you said, he wasn't handcuffed or in any way restrained to that bed, was he?
He was not.
And there were no officers standing at the door or otherwise supervising that room, were there?
No.
And through your investigation, you determined he's located at an apartment complex at around 3:40 a.m. Is that right?
That's what is in the report. I think I listed a time in there. If you want me to look at to refresh my memory.
It would refresh your recollection to look at your report?
It would.
Okay. Your Honor, if I may approach the witness.
I think it's.
He's got a copy
Okay.
that was turned over, so if you look at that, you believe that will refresh your recollection.
Yes, I did. He was located about 3:40 a.m.
Okay. And he's returned to the hospital. The blood draw was completed at 4:28 a.m. And of course, there's two blood draws done. So it's 4:28 a.m. and 4:29 a.m. Does that sound right, officer?
That sounds correct.
Okay. So in an ideal OWI investigation, you want to have eyes on the subject from the time you make the scene until the needle enters the arm, right?
I do. Yes.
Okay. One of the reasons you do that is to make sure the subject doesn't consume anything that could impact the blood test, right?
That is correct.
And Mr. Magoo was unaccounted for nearly an hour in this case, right?
That's correct.
And in your search warrant affidavit, You didn't mention that, did you?
I don't believe so, no.
Thank you for answering my questions, Your Honor. I have nothing further at this time.
Read your.
Thank you, Your Honor. Officer Corey, were you able to obtain information that the defendant had previously been pulled over by a different police agency operating this car in March of 2023? And after he was recovered and brought back to the hospital, did you have two deputies stand by with him and handcuff him to the gurney?
I handcuffed him myself, but luckily I had a couple of deputies that were free for the moment that were able to watch him while I finished up the search warrant.
Thank you. Nothing further, Your Honor.
Anything?
Your Honor, if I may, one.
May want to mute your microphone.
Your Honor, just briefly. Thank you. Officer.
Oh, and can I just ask one other question before you, and I'll let you ask your question.
Of course, Your Honor.
The PT, if there's,
Alex, muted.
okay, the PBT, are people going to seek admission of that if defense is challenging the results
Yes, Your Honor.
pursuant to the statute?
Correct.
And Your Honor, I understand that the people could rebut that kind of challenge. I'm not sure that we have gotten to that point yet. The case law.
Well, I just want to make sure that if there is going to be a challenge to the results, that under the statute, my understanding is, although these aren't entirely the circumstance under which it happens, but it seems to me an analysis could be made that the PBT would then become admissible. Just so that defense counsel is aware, but you may inquire.
Thank you, Your Honor. I appreciate it. Officer, before Mr. Magoo was admitted to the hospital, did you yourself search him? Search his person?
It's outside the scope of my redirect, Your Honor.
I'll allow you to ask. Go ahead.
He was wearing a jacket, right?
I believe so, yes.
Do you go through all the pockets of that jacket?
I normally would, yes. I believe I did.
Okay. Officer, when you completed the refusal to submit to chemical test form, in this case, do you recall writing the refusal time as 1:35 military time?
No, I don't recall that.
Would it refresh your recollection to look at the refusal to submit to chemical test form you completed?
I would. I think.
Yes.
Seems that I did. I don't recall why I would put that time there.
Well, again, officer, thank you for answering my questions. Your Honor, I have nothing further at this time.
All right. Ms. Lundy.
Officer Corey, you would agree with me that this says refusal date, but it does not say refusal time, correct? It just says military time?
Correct.
Okay, thank you. And lastly, Your Honor, in anticipation of an argument that the blood result is not accurate, I would ask a question about the PBT, but if that argument's not going to be made, then I don't need to.
Your Honor, I would object to any mention or admission of the results of a preliminary breath test in this matter. I'm not sure that I have raised an argument that regarding its accuracy or regarding a rising blood alcohol level or anything like that. I don't think I've opened the door for that.
Well, I don't think you have. I just want to make sure we're prepared for the argument. But if that argument is going to be made, then I'm going to let the people question as to that. But
Your Honor, I don't anticipate making an argument regarding a rising blood alcohol level or anything to that effect at this point.
well, but are you going to make the argument that the blood alcohol result at the time of the test, well, I'll just do it this way, is it lower or higher than the?
Your Honor, I intend to make arguments on what has already been stated on the record, and I'm not going to.
What does that mean?
From the defense, I don't anticipate any further questioning regarding the blood alcohol results from either the lab or the preliminary breath test.
Okay, again, that was very cagey the way that was put, but I'll just put it this way. What I will do, Ms. Lundy, is I will not permit the questioning at this point. However, if it is raised in argument, I may entertain a motion by the people to reopen their proofs to take testimony regarding that. If
Thank you, Your Honor.
Understood, Your Honor. Thank you.
I have nothing further.
all right. You may step down, sir. Thank you. Yeah, shut down. I'm not done. So the system went down?
Yeah, it says that my calls are still recording, but.
We don't know.
Software shut down.
I'm not gonna take a chance. Do we know when it happened just now?
Just now.
Just now, okay. What the court's gonna do is court's gonna stand in recess. We need to take it back up.
Understood. Thank you.
It's worked too hard today. Court's in recess.
All right.
Well, guys, we've come to the end of this proceeding prematurely. Unfortunately, the court system started to act up and they had to cut this thing short. But as we can see, man, a lot has happened today. In spite of having the lawyer, Mr. Magoo had to get something on the record. He had to say something that's just kind of in his nature. But we finally get to hear the officer testify, which Magoo's been asking for quite a while, to have an opportunity to cross-examine the officer, which now, because he has the attorney, he did so. And, you know, just being able to finally hear some of the events that happened leading up to the hospital situation that we've been hearing about, him escaping and leaving the hospital. You know, the officer finally tells about that. We see that Mr. Magoo, with his injuries, you know, the damage at the crash, his blood alcohol level, he definitely was super, super duper drunk. And maybe him being locked up right now, maybe helping him in that area. Who knows? Because it sounds like he may possibly definitely, or I said possibly definitely, but that he may definitely have a drinking problem. But something I want to note on cross-examination, I noticed Mr. Magoo's lawyer, you know, he was asking questions about, you know, was he handcuffed? Was an officer guarding the door? So on and so forth. And I'm just wondering later on if he's going to say that Mr. Magoo didn't know that he was under arrest and that's why he left. You know, I thought that was interesting questioning by his attorney for the officer. But nonetheless, once again, system went down. So we're going to have to wait and see when they pick this case back up. Not sure if it's going to be tomorrow or not. I got to definitely go ahead and look into that because I don't want to miss it. But with that being said, guys, finally we get some details. Finally, we hear some of the story that we've been waiting on, and I'm looking forward to hear the rest. But once again, always, thank you for joining me here at Sovereign Citizens Hall of Fame. Don't forget to like, share, comment, subscribe. Give me your thoughts on what's happened so far in this case. And with that being said, guys, this is Sovereign Citizens Court. And for now, Sovereign Citizens, I'm tongue tied again, guys. Sovereign Citizens Court is adjourned. I appreciate you guys, and I'll see you guys soon. God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.